All right, Mr. Harwell. Is that
Yes,
right?
Your Honor.
Yeah, good afternoon.
May it please the court, my name is Jonathan Harwell. I'm here on behalf of the defendant appellant Hayden Berkebile. If I could reserve 4 minutes of my time for rebuttal.
Certainly, 4 minutes.
Yes, Your Honor.
All right, thank you.
I have 3 claims I would like to get to. 2 claims are sufficiency claims, but different sufficiency claims. And the 3rd claim is a territorial jurisdiction claim. I won't dwell much on the truly tragic facts of this case. As the court is aware, this arose out of a relationship, a troubled relationship. There were discussions of harming, of suicide, of Russian roulette, and the decedent ended up shooting herself at a time she was in a FaceTime call with the defendant. The defendant immediately contacted law enforcement, and her death was then discovered. I want to first talk about what I think of as the proximate cause issue. And I'd like to do it, I think, in terms of the briefing a little bit, because I think we've sharpened the issue. So in our initial brief, I made a number of different proximate cause arguments, sort of, I don't want to say scattershot, but maybe that's what they were. Partly because it is my position, is we don't know what caused or what led up to the death of the decedent. And have argued that proximate cause was lacking as to a lot of the possibilities that could have led to that. The state has, I think, sought in its brief to find the sweet spot of making the best proximate cause argument, and has put forward a single theory of what happened here. And as I understand this, in the state's brief, pages 25 to 27, the state's theory is that they agreed, the defendant and Ms. Sparks agreed to engage in a kind of Russian roulette in which he had the role of monitoring the revolver to see if the bullet was actually in the chamber, that they played that game, that Mr. Berkebile was aware that the bullet was actually in the chamber, and that he failed to faithfully execute his job of informing her, hey, don't pull the trigger this time. As I understand that, this theory of Russian roulette, he knew the bullet was in the chamber and he kept quiet. That is what the state has now asserted was the basis of Mr. Berkebile's conviction. I assert there's 2 problems with that. The simpler problem is that's not what the state said at trial. The state said a lot of things at trial, different versions of why Mr. Berkebile was guilty, an opening statement and closing argument, a rebuttal closing argument. But this, he knew and he kept quiet theory, I don't believe can be found in the trial transcript. The other problem, equally important, is the proof doesn't support that theory. In the sense, and this is a spectacularly complicated case to boil down to sort of just on this issue, Hornbook application of sufficiency analysis. You can't have sufficient evidence for a criminal offense if it's based on conjecture, guess, speculation, or a mere possibility. It's our position, the state's argument that he knew the bullet was in the chamber and he kept quiet and he shouldn't have and she pulled the trigger, that's a mere possibility. It could have happened, I can't rule it out, but it also could have happened many, many other ways. As we've talked about in our brief, this is conduct that they engaged in that is clear that they did it from the record, but it's not clear what they were doing in the record. This is also a situation where this happened on a day which she had been told by her live-in boyfriend that she was to discontinue the relationship with Mr. Berkebile, that she was also told by Mr. Berkebile that he was not going to be able to visit her, as they had both been looking forward to. So you have a multitude of possibilities of what led up to the moment where she pulled the trigger. The state has picked one and has put its eggs in that basket. It's our assertion that that choice, based on this record, is sheer speculation. And so for that issue, even if maybe the state's theory somehow answers the probable cause argument, it is a theory that does not have a sufficient factual basis. And the flip side of that is those other theories that I did try to address in my opening brief and point out why proximate cause wasn't available for those either. The state has waived reliance on those by not presenting them to this court. To move to my second issue, and that is the speech alone issue. And I think it's important for this issue to understand something a little bit different in that criminally negligent homicide, I guess we don't have common law crimes. But if there's something that's as close to a common law crime, that's what criminally negligent homicide is. You have a very basic statute saying criminally negligent homicide is, homicide that's done after a criminally negligent act. And then you have a world of interpretive law setting out what that means. So proximate cause, so independent intervening act, all of those things are developments by the courts interpreting a very basic criminally negligent homicide statute. It's our assertion that although I don't think this has ever had to been dealt with by the courts of Tennessee before, criminally negligent homicide also has to have an exception that the statute does not cover constitutionally protected speech alone. And so the basis of this argument, we're not saying that the statute properly interpreted violates the First Amendment. We're saying the statute properly interpreted incorporates the First Amendment. And the First Amendment, as I've tried to set out in the brief, says you can't criminalize, you can't punish speech alone other than in a few very narrow exceptions. Excitement to imminent lawless action, fraud, true threats, speech that is an integral part of criminal conduct. The twist to this, and this is something that I commend to the court, the decision of the Minnesota Supreme Court in a case called Melchert-Dinkel. The twist to this is that the linchpin of the analysis of the Supreme Court of the United States in cases like Gaboni versus Empire Storage, the linchpin of a lot of these has to do with you can't incite unlawful activity. You can't use speech as part of unlawful activity. The twist is, however unfortunate, unhappy, tragic suicide is, our legislature has not actually said that's criminal. That gives us a situation where even if the state were to prove that someone like Mr. Berkebile had directly encouraged, suggested, advocated for someone to kill themselves, if all they have done is engaged in speech, that is protected speech. And it's my argument that protected speech doesn't fall under the criminally negligent homicide statute.
So what type of speech is it that, we always heard in law school about you can't walk into a theater and scream fire? That's not protected under First Amendment, correct?
That's right.
Maybe I'm just not connecting on this. How is, when someone is standing in front of you or on a monitor and they have a weapon and you say, pull the trigger, how is that any different from walking into a theater and screaming fire? Maybe I'm missing something here.
And maybe I'm missing the explanation. The problem with walking into the theater and yelling fire is if there is no fire, right? Because it's false. So I guess that would perhaps bring it under the fraud exception.
Okay.
You can't, deceptive conduct maybe is not protected by the First Amendment, or conduct likely to lead to a riot in the movie theater that is unnecessary. Here, I think we're just talking about the consequences of the legislature's failure to criminalize suicide. I would not have this argument if there was a statute saying that suicide was against the law. But what we have here is a question of, is our penal statute, criminally negligent homicide, is that going to cover a situation where through words alone, someone has encouraged, induced someone to do something that is, we all agree is bad, but is in fact not illegal. And the United States Supreme Court in Gaboni and all the other cases have talked about its imminent incitement to illegal activity. It is speech that is integral to criminal activity. And so that's why Minnesota Supreme Court said, however lamentable suicide is, if it's not illegal, then speaking by words alone, again, be different if Mr. Berkebile had given her a gun, had given her the bullet, had been there physically assisting in some way. We're talking here about speech alone. So it's our position that criminally negligent homicide under the doctrine of constitutional avoidance has to be interpreted. As I said, it's already kind of a common law crime. It has to be interpreted to not cover situations of speech alone when those instances of speech alone are constitutionally protected. And the final issue I want to talk about is the territorial jurisdiction issue. Obviously, Mr. Berkebile was in Indiana during this whole time period, had not been in Tennessee, at least for weeks, if not months. And any contact was just electronic and or telephonic. It's not a case, not an issue that arises very often. There really is, as far as I could tell, only one really close analogy. That's the Audra Lynn Johnson case from this court in 2006. And what that panel did in that decision was correctly to look at 3911-103, kind of a weirdly written statute. But what this court said in Audra Lynn Johnson is that even if an offense is consummated in the state of Tennessee, which we concede a homicide offense is consummated where the person dies. Even if an offense is consummated in the state of Tennessee, there is a defense for a defendant who remains outside the state the entire time unless the defendant has employed a guilty or innocent agent, or the defendant has employed other means proceeding directly from the person. So I think the state sort of agrees that we are here interpreting this phrase, one phrase, other means proceeding directly from the person. It's our position, it's my position, and essentially I think this is supported by a gloss of that phrase in the Audra Lynn Johnson case, is other means proceeding directly from the person refers to some kind of physical activity. So Audra Lynn Johnson talks about someone standing over the border in Kentucky and shooting into Tennessee. And we don't have that here. There was the gun wasn't sent by Mr. Berkebile, bullets weren't sent, nothing physically was done by him that passed into the state of Tennessee. And the other thing I want to say, and this is something that I think I did not do a good job in my reply brief of pointing out, it's in there, it's not made as forcefully as I think I should have. And that is, in the state's brief, at page 33, the state says, the key to territorial jurisdiction is the deliberate attempt to cause a crime to occur in Tennessee. And I think that answers the question here on these facts. Deliberate attempt to cause a crime to occur in Tennessee. The state didn't charge a deliberate attempt. They have not argued on appeal that there was a deliberate attempt. What they have argued is that there was a negligent failure to act. And if the state is conceding that you only get territorial jurisdiction if you have a deliberate attempt to cause a crime to occur in Tennessee, then on these facts, there clearly was not such. Even if the state's theory were accepted and found to be sufficient as a matter of establishing criminally negligent homicide, arguing that Mr. Berkebile remained silent at a time when he should have spoken up is not, that's not a deliberate attempt to cause a crime to occur in Tennessee. So I think I will reserve the rest of my time for rebuttal if there are no questions at this point. Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the Court. My name is Garrett Ward. I'm here this afternoon on behalf of the state of Tennessee in the matter of State v. Hayden Berkebile. Your Honors, this Court should affirm the defendant's convictions because the evidence was sufficient to support this conviction, and the state had territorial jurisdiction over this crime. As opposing counsel did, I will devote my time before this Court to the sufficiency and territorial jurisdiction issues and rest on my brief for the remaining issues, although I'm happy to answer questions should this Court have them. Your Honors, turning to sufficiency, this case is, I hesitate to ever use the word unique in this field, but this case is at the very least unusual. It has sort of this combination of facts that I have not run across before in my time at the Attorney General's office. Many of these facts are salacious, and some of them are, frankly, disturbing. But at the core of this case, looking through the facts, our core legal inquiry here is around one of the maybe the most fundamental legal concept, especially in criminal and civil liability, criminal in this case, of negligence. So our core inquiry here, despite the fact that these facts are so novel, our core inquiry here is a familiar one. It's, did the defendant, because this is criminal negligence, did the defendant sort of grossly depart from a standard of care resulting in the death of the victim, in this case, Ms. Sparks? Your Honors, as I understand the defendant's sufficiency challenge, it is largely in the proximate cause field, at least preliminarily. His initial challenge is in the field of proximate cause. And Your Honors, although it is impossible in a 20-minute argument to fully convey the facts of this case, I believe at least a brief discussion of them is frankly necessary to understand proximate cause here. Your Honors, a large percentage of the proof in this case was roughly 10,000 Facebook Messenger messages exchanged between Mr. Berkebile and Ms. Sparks, the victim here. In these messages, as are most relevant to our inquiry here on appeal, because there were a great number of messages which were over routine everyday topics like pets and work frustrations, things of that nature. But as relevant to this appeal, we glean a great deal about both their relationship and what happened on September 29th, which was the day that Ms. Sparks passed away. What I'll first start with is what we know about their relationship overall from these messages, because the nature of this relationship is really central to the negligence question. Your Honors, without passing any judgment or making any statement about this relationship, Ms. Sparks and Mr. Berkebile were engaged in a relationship of a sexual nature that depended at its root on Ms. Sparks engaging in forms of self-harm and pantomime suicide for the defendant's sexual excitement. That is crystal clear from the proof in this case. What's also clear is that to effectuate this odd relationship, on a number of occasions, the defendant encouraged the victim, and she agreed on these earlier occasions to engage in some sort of, I'll use the term game here as perhaps broadly as it can possibly be used, to engage in a game that resembled Russian roulette. What is clear from their discussions pre-September 29th is when she would engage in this game for the defendant's sexual gratification. Ms. Sparks was, to the extent one can be protected while playing Russian roulette, was protected because she was able to see which chamber of her gun was loaded, so she wouldn't actually claim her own life. That was, as astounding as it is, that's what the proof shows happened on multiple occasions in this case, which brings us to September 29th. On September 29th, there is a great deal of discussion about engaging in this sort of Russian roulette play again. Then there is a video call. That video call wasn't, I believe, was on Facebook Messenger, despite the fact that the logs were preserved. The video itself wasn't preserved. I haven't seen it. Mr. Harwell hasn't seen it. Nobody in this case has actually seen this video call. But what occurs during this video call is a gun discharges and Ms. Sparks dies. Now, Mr. Harwell, opposing counsel, has suggested that we don't actually know what happened on this call, and therefore both we have failed to prove sort of proximate causation and just on a more baseline level, and failed to prove anything beyond speculation. And, Your Honors, I think a helpful way to view this issue is if this court were to regard the call as sort of the call itself as a play. We have the stage directions for it in their messages from September 29th. We know from their discussion on September 29th what was going to happen on this call, and I'll briefly run through those messages. Ms. Sparks offers to engage in this Russian roulette style game. She offers to do that for Mr. Berkebile. Mr. Berkebile tells her that the game doesn't really work because she knows where the bullet is. Ms. Sparks responds, well, essentially, well, I can fix that. I could wear a blindfold or I could close my eyes. She goes on to say, and then you would know where the bullet is and I wouldn't. You'd get to decide whether I lived or died. Not me. You, Mr. Berkebile, would get to decide that. Later on in their conversation, when Mr. Berkebile asks her if the thought of dying excites her and she says no, she tells him that, and this is explicit in her text messages, she tells him that she trusts him to not actually allow her to die, that she trusts him to enjoy the trust and power she's granted him and has placed in him, and then to not allow her to die. Which brings us to the call, because obviously during this call she does die. And I'd contend to this court that she dies as a direct and proximate cause of the defendant's action or inaction. What do these messages tell us? What they tell us is that unlike all of these other times where Ms. Sparks and Mr. Berkebile had engaged in this game, unlike all these other times Ms. Sparks was sort of taking the responsibility for her safety. She was taking it out of her hands, and it was being granted to and accepted by the defendant. She wasn't the one that was going to know which chamber was loaded, it was him. She trusted him to not actually allow her to die. We then know that despite that, she does pass away. A gunshot fired through the back of her mouth that was self-inflicted. And I'd suggest to this court that although the jury didn't see the actual play, what the jury sees in these messages allows them to reasonably infer what happened on this call. These messages show beyond any real doubt that this responsibility to identify the dangerous chamber that fell to the defendant, that was their agreement, at least on September 29th, that this responsibility didn't fall to Ms. Sparks. The jury knows that these two agreed to do this together, that the defendant was given this duty and accepted this duty, and that Ms. Sparks died. And a reasonable inference for the jury to draw is either that Mr. Berkebile saw which chamber was loaded and chose to say nothing, or that he just didn't carry out his duty very well.
Was there proof that she was blindfolded?
No blindfold, Your Honor, and perhaps inartfully in my brief, I at one point suggest that there was a blindfold, but she does say she could just close her eyes. That's what she offers up for doing, and you know, she initially says that about 30 minutes before this call occurs, and then closer to 5 or 7 minutes before the call happens, she says she'll do it with her eyes closed. So no blindfold, but she does say she's going to close her eyes. And the jury can reasonably infer that she did what she said she would do. So I'd suggest to the court that when a person, like in this case the defendant, agrees to participate in such a wildly dangerous activity, that this agreement is sort of created between the parties with the specific understanding that the defendant has this, I'll use the term broadly again, this sort of safety responsibility, and that ultimately the one of the parties, in this case Ms. Sparks, passed away via a gunshot wound, which was intended to be the identification and prevention of the loaded chamber going off was the safety responsibility in this case. That is all a reasonable inference for the jury to draw based on what Mr. Berkebile and Ms. Sparks said they were going to do. The jury could draw this reasonable inference and conclude that her death was proximately caused by the defendant, because if he had discharged his responsibility successfully or chosen to discharge it at all, her death could have been avoided. But that's not what happened. And I'd suggest, Your Honors, that is sort of negligence in a nutshell. A person accepts this sort of responsibility and then in this wildly dangerous situation and fails to faithfully carry it out. That, through all of these weird facts, that does get us back to negligence, and that's the crime at issue here. I'll briefly touch on on this First Amendment issue. Your Honors, this issue to me doesn't really smack of sufficiency. Your Honors, this issue seems to be an as-applied challenge to an as-applied First Amendment challenge here that was never litigated before the trial court. There was no mention of First Amendment protections anywhere in the trial record. The record is extensive, but nowhere in it is there any indication that the defendant thinks his prosecution somehow runs afoul of the First Amendment. And although the First Amendment is certainly a basis on which to challenge criminal prosecutions, what's clear is that constitutional sufficiency and constitutional First Amendment protections are different things. They raise different issues. They're dealt with under different standards. Your Honors, this is essentially an as-applied challenge that the defendant is seeking to sort of bootstrap onto a sufficiency challenge because he's waived his First Amendment challenge, but he can't waive his sufficiency challenge. By not asking the trial court to examine any of this on First Amendment grounds, he's waived that review before this court. Briefly, Your Honors, I'll address, presuming it's not waived, there is more than speech here. Certainly, Your Honors, there is a great deal of speech in this case, 10,000 text messages. But it is not the speech itself, but the agreements and duties and undertakings and safety responsibilities that this speech sort of represents. That this speech really, in this case, what it is most properly viewed as doing is communication between the two parties about what responsibilities are, and it's certainly strong evidence of negligence about the failure to properly undertake these responsibilities, but it's the responsibility and the failure to execute it that is at the core of this case. Yes, evidence of it is speech, But simply put, using speech as evidence doesn't run afoul of the First Amendment. The defendant's conviction here isn't simply because he said any of the statements in his text messages. It's because he reached this agreement with Ms. Sparks. He had this duty and he failed to properly carry it out. As a final matter, Your Honors, on territorial jurisdiction, I think there is a great deal of agreement between the defendant and the state on how to approach this question. I think all parties agree that this offense was consummated in Tennessee. It's a homicide. The victim died in the state of Tennessee. Our only real disagreement seems to be, did the defendant directly reach out to Tennessee or use other means directly from the person, I think is how the statute specifically words it. And Your Honors, he simply did in this case. There was no accident in the defendant reaching out to Tennessee. He knew where Ms. Sparks was located. They talk about her location repeatedly throughout their messages. He knew where his action, he knew he was reaching out to the state, and that's the core of territorial jurisdiction. As I so often find at oral argument, it appears there's something I worded a little inartfully in my brief about deliberate attempts. The state's position is certainly not that this is binding the state to use sort of an intentional mens rea for the terms of committing a crime. My only point there is that the defendant the putative defendant in a territorial jurisdiction case needs to have meant to reach out to Tennessee. And I think this really dovetails nicely with State versus Alderland Johnson. Like opposing counsel said, there's not a great deal of case law on territorial jurisdiction. Alderland Johnson is a good example of territorial jurisdiction analysis. What we had in that case was a second-degree murder prosecution stemming from a fentanyl sale. This was a fentanyl sale that occurred in Indiana. The defendant sold fentanyl to the victim. The victim then traveled, proof in that case shows completely unbeknownst and unexpectedly to the defendant, traveled from Indiana where the sale occurred down to the state of Tennessee, took the fentanyl, overdosed, and died. And what the court noted in Alderland Johnson, court heavily quotes from a Kansas Supreme Court case. I'm going to quote some specific language from Johnson because I think that really gets right to the heart of territorial jurisdiction, and specifically the defense that is at issue in this case. So this territorial jurisdiction defense is for a defendant who was located outside the state, didn't intend to commit a crime within the state, and could not reasonably foresee that his act would cause, aid, or abet in the commission of crime within this state. Your Honors, it is entirely reasonably foreseeable by this defendant that his actions would cause this effect within the state of Tennessee because the person he's conversing with is in the state of Tennessee and he knew it. Yes, this is digital means. The defendant doesn't throw a rock across the border. He doesn't mail a pipe bomb. He reaches out directly to the state of Tennessee digitally. This is the 21st century prosecution. We need to deal with territorial jurisdiction in the 21st century world. And in this world, one who digitally reaches out and does so directly falls within the jurisdiction of the state of Tennessee. The defendant's position really seems to focus on this physical nature of the word direct. And Your Honors, in a great deal of cases, reaching directly out to Tennessee might be accomplished through physical means. But if I send an email to my father, I've directly reached out to him. And if I know him to be located in Tennessee, I've directly reached out to a resident of Tennessee in the state of Tennessee. So I've reached directly out to Tennessee. I think that notion, the state's interpretation of direct means, gels much more nicely with what this court indicated was the heart of territorial jurisdiction in Johnson, and the defendant's sort of approach that relies on physical action is rather cramped and isn't fully cognizant of the way persons in 2023 interact with the world. If this court has no further questions, I'd ask that you affirm.
Let me ask just one quick question.
Certainly, Your Honor.
And I believe I'm recalling this from the briefs. There was proof in the record that this defendant knew of the victim's fragileness, I'll call it. That she was a fragile victim or individual. Mm-hmm. Is that correct?
Yes, Your Honor.
In fact, at trial, did not her boyfriend testify for the defense to those facts, that she was fragile?
There was some testimony from not Mr. Berkebile, but from another man who the victim was romantically entangled with. There was some testimony about her mental state. I'll note for the court that wasn't the only testimony about her mental state. I'll also note for the court that although this other boyfriend was speaking about her mental state, what the proof in the record showed at the time was that he was deployed overseas. So his knowledge of what her mental state would be like, I don't know that we can hold that out as perhaps the most shining example of accuracy, because he's not there with her. People at trial who were with her didn't paint such a bleak picture of her mental state as this defense witness did. Certainly there is some degree of mental illness and depression that seeps all through this case. But from the way the victim talks in the moments leading up to her death, it does not read, her messages don't read as somebody who is imminently planning to kill herself. Some of the last things she does are share pictures of her pets with defendant and talk about how excited she is that her kitchen has been renovated. That and other witnesses that testified who were with her, who weren't across the ocean, that's a better picture of what her mental state might have been like. Thank you, Your Honors.
Thank you, General. Rebuttal?
I have 3 points I would like to make. The first, on the first sufficiency issue, I think that there's something to, I think maybe I like the state's description of this as a play, in the sense that there was a script that the state has maybe deduced from the messages. But what the state's position on appeal is that what happened was that the parties followed the script through a bunch of the steps of the script, but that Mr. Berkebile departed from the script at some point, and that's how she died. And as I have said, that is an entirely possible thing that happened. But what a jury has to find is not that something is possible, it has to find that something happened and that there is no reasonable doubt that it happened. Here, there is a multitude of other ways that things could have gone off the script. This could have been an accident. This could have been Mr. Berkebile, as he said, telling her, don't shoot yourself, stop, and her doing it anyway. It could have been them playing this game to completion and then her shooting herself after the game is over. The idea that because she died, we can reason backwards that therefore they must have been playing the game in this way, and he must have seen the bullet, and he must have decided to keep quiet about it, that's just speculation. And because of that, it doesn't establish proof beyond a reasonable doubt. The second point to make is, again, just to clarify, I'm not making a standalone First Amendment argument. We're making a statutory interpretation argument. We are using the principle of constitutional avoidance. Tennessee Supreme Court recently cited to that in State versus Booker as a perfectly legitimate way to interpret a statute. In fact, it's better not to say we're going to interpret a statute broadly, but then say it's unconstitutional. The better way is to interpret a statute so it doesn't even go over to where the Constitution reaches. The final point I want to make is on the territorial jurisdiction. I think there is clearly a difference of how to interpret the relevant phrase. I have put forth a interpretation in my brief. The state has its interpretation of the brief, other means proceeding directly from the person. To me, that speaks of from the person. It's not so much directly, but from the person has to do with something physical. The state says no, emails proceed directly from the person. But there is and I didn't bring this up in my original argument, there is a solution to that problem when you have a phrase that is susceptible of different meanings. And in the penal criminal context, that solution is the rule of lenity. And here, where this phrase can be interpreted, I think reasonably in both ways, the appropriate solution is to say, for now, we will interpret it in favor of the defendant. If the legislature thinks otherwise, if the legislature thinks in the 21st century we need to make clear that this covers electronic communications, the legislature can do that. But when it has not done so, the rule of lenity says that this interpretation should be done against the state in favor of the criminal defendant. And in that situation, we simply do not have territorial jurisdiction. So we would ask that the court enter a judgment of acquittal on the one charge against Mr. Berkebile. Thank you.
All right, thank you, Mr. Harwell. Well argued and well briefed. We'll take the case under advisement. And I think that concludes our docket for this afternoon. So we'll be at recess until tomorrow morning at 9:30 a.m.
All rise. This honorable court of Tennessee stands adjourned until 9:30 tomorrow morning. Thank you.